Good afternoon. We'll call the case of McLain versus Lobert.
Good afternoon, Your Honors.
Good afternoon. This is a 20-minute grant. You may reserve time for rebuttal, but we ask that you keep track of your own time.
Thank you. Chief Justice Clement, I'd like to reserve 3 minutes if possible, and I hear that admonition, and I will try my best to keep track myself. Your Honors, my name is Christopher Desmond. I'm here from Johnson Law today on behalf of the plaintiff, Brian McLain. I'm joined at counsel's table by Ven Johnson, also from Johnson Law. And Your Honors, I'm happy to waive any free fire period that I have today. I know that I could see there being a lot of questions because I think that there are a lot of issues that are raised by this case regarding both of the issues that the court has asked us to brief today. So, Your Honors, the statute that's at issue today, MCL 600.5851B, this is a statute that was passed in 2018 by the Michigan legislature. And it was passed by the legislature because of the sad reality that we've learned in this state over the last several years. We've had a number of instances between both the University of Michigan, the University of Michigan State, that have demonstrated what a lot of mental health professionals have taught us for years, which is that child victims of sexual assault, for a variety of reasons, there are different phenomena that operate that make it less likely that those individuals will come forward in the years immediately following the act of abuse that harmed them to report that abuse. And as a result of that, there were individuals who were losing what were otherwise meritorious or viable causes of action against their tortfeasors simply because of operation of the statute of limitations, not because of the lack of merits of that individual victim's case. And so in 2018, the Michigan legislature passed MCL 600.5851B. And one particular provision of that act, which is section 1B, so 5851B 1B, provides that an individual who was a minor at the time of their sexual assault can bring a cause of action within 3 years of the date that they connect the act of sexual assault that they endured to the damages that they're alleging that they suffered. So that passage, again, happened in 2018. In 2020, my client, Brian McLain, who's within this class of individuals who was abused, sexually abused as a minor, Mr. McLain's abuse happened in the 1990s while he was a resident at the Maxey Boys School, and it happened at the hands of a priest who was assigned to that boys' school. But Mr. McLain hadn't previously made the connection between that act of abuse and a variety of damages that he suffered and that we now know he suffered as a result of that abuse. So when he made that connection in 2020, our position is that we're not seeking a retroactive application of this statute at all. We're seeking a prospective application of this statute. The statute was passed in 2018. Moving forward prospectively in 2020, an event referenced by that statute occurred, which is Mr. McLain making the connection between his act of sexual abuse and the damages that he incurred. And so I don't believe that this court needs to touch on the issue of retroactivity today in order for Mr. McLain to prevail. One of the areas that I point the court to, one of the cases that I point the court to, and I emphasize this in my reply brief, I think it's an extremely important case for this court to consider when we look at what the legislature was trying to do in 2018, and that's the Trentadue case. So the Trentadue versus Gordon case from this court. So prior to the issuance of the Trentadue opinion, the state of Michigan essentially abided by a common law discovery rule, which said that a cause of action accrues when the wrong initially occurs, regardless of when damage results or regardless of if all the elements of that cause of action have been discovered. But the common law discovery rule recognized that there'd be certain instances where a plaintiff was precluded from timely bringing their cause of action because they didn't know of an essential element of their cause of action.
Under your reading of the statute, is there any limiting factor? Is there any limitation, or could it be 70 years?
Under B1, no, there is no limiting factor. There's
none.
no limiting factor, not under B1B. Not under B1B, there's no limiting factor. So there are limiting factors placed elsewhere throughout the provision. So we have by the age that you're 28 years old, within 10 years of the occurrence of the sexual assault. But for individuals who are operating under this discovery rule portion of this new provision, there is no limitation on that, Your Honor. Honor. And I think that that's consistent, again, with what we see in a case like Trent to Do, and a case that preceded Trent to Do called Larson, which was an asbestos case, where they talked about the nature of asbestos poisoning is that sometimes you don't know you were poisoned until 40 years after you were poisoned, until well after a statute of limitations is gone. Well, the legislature understood that child sexual abuse is very similar to something like asbestos poisoning in that regard. Oftentimes, the victims don't know about it until that statute is gone. Our legislature recognized that ill, and they wanted to remedy that ill by the passage of MCL 600.5851B. And so they did not put any cap on that whatsoever, Your Honor. Now, I know we've heard there's been some rhetoric, particularly in the amicus brief, that talks about, well, how could that be? How could you possibly allow a case to go forward when evidence could be stale? Memories of victims have faded. People may not even be alive anymore. But I'd submit to this court that, first of all, it's not the business of this court to be engaging into those policy criticisms of our legislature. If our legislature has the authority, the constitutional authority to pass the statute at issue in this case, which no one contests that they do, if they have that authority, then it's simply a matter of their own wisdom and whether or not they saw fit to enact the statute that they did. In terms of the difficulties that could pop up from a litigation standpoint, frankly, those are the difficulties for the plaintiff to bear. The burden in this case is going to be on Mr. McLain. And so when we go to trial, to the extent that memories have faded or that evidence may not be as strong in the minds of the defense, that's something that the defense is able to point out to the jury, and at the end of the day, it's a decision for the jury to make, not a decision for this court to make, looking in hindsight at the wisdom of the legislature.
Counsel, how do we square, assuming I agree with you on the accrual and how it works and that the claim can accrue later, how do we avoid a retroactivity analysis if the statute of limitations has expired, as in the case of your client?
Well, because I don't think the statute of limitations has expired in the case of my client because of this 2018 passage of the bill.
So you think it sort of revived
the claim? That's right, Your Honor, that's right. And you know, the United States Supreme Court, by the way, has said that that is completely permissible. This is in a case called Chase Security Corp versus Donaldson. The United States, and I can give the court the site, it's 325 U.S. 304, and this is at page 314 specifically. The United States Supreme Court recognized that we can amend statutes of limitations even after they've expired completely. That we can do that, and that doesn't raise any due process concerns, that doesn't violate the rights of the individuals who are affected by that expanded statute of limitations. I know we haven't necessarily, we weren't in retroactivity yet, but I do think that this is a good way to pivot into retroactivity, because one of the things that has jumped out to me so much in my prep of this case is this issue, because when the U.S. Supreme Court says, yeah, you can amend a statute of limitations after it's expired, that's fine. Well, they're really kind of talking about this concept of vested rights, which is what we're concerned with at really the third and fourth, we call them LaFontaine factors. I think, by the way, we've done those factors a big disservice by calling them factors. I don't think they are factors. If we go back to the in-ray certified question case from 1982, this court always called those four principles rules. They were referred to as rules, or they were almost seen as categories that statutes or cases could fit in. With LaFontaine, we started calling it factors, and I think it's compelled some weird decisions from courts, because now we get into it and we think, well, how does factor 1 apply to this case? How does factor 2 apply to this case? And the reality is it might not. It might not apply to the case at all, because it's not a factor like a best interest factor is, for example, in a child custody case where we know we have to go through all of them. But the third and fourth principles or rules that we're concerned with deal with this issue of vested right. And so the U.S. Supreme Court has said it doesn't violate anyone's right to change a statute of limitations after it's expired. The Court of Appeals, interestingly to me, especially in light of this court's recent jurisprudence, and in fairness to the Court of Appeals, their decision came down before this court's decision in Andari. But the Court of Appeals said in this case, well, both sides have offered us authority regarding whether or not the right at issue in this case is vested. And they said, plaintiff has the Besmert-Naha case. Besmert-Naha was a case decided in 1991 by the Court of Appeals. And in Besmert-Naha, and I quoted in my brief, and it's as unambiguous as it gets, the court says, there is no right to defeat a cause of action through the interjection of a statute of limitations. That is just not a vested right. So that's what Besmert-Naha says in 91. Well, the Court of Appeals said, yeah, but the defense gave us the Gorte case, Gorte versus Department of Transportation. Well, Gorte was decided in 1993. There was no declaration by the Gorte court that there was a conflict with Besmert-Naha. They didn't call for a conflict panel. So we know under the rules of this court, they can't deviate from a published opinion that comes down in 91 from the Court of Appeals in 1993. But beyond that, Gorte was a very distinguishable case from this case because it was a property case. It wasn't a case that involved civil liability and civil statutes of limitations. It was an eminent domain case. And the court in that case, when it says, it implies that there could be a vested right related to the expiration of statutes of limitations. It cites to this court's decision in People v. Russo. And I think People v. Russo is a fascinating opinion for this court's purposes today. Because, by the way, People v. Russo did not, nor did Gorte, they did not involve situations where the court said, we're not going to retroactively apply this statute because it would be unfair to the defendant. That's not what they did. In People v. Russo, they were dealing with a retroactive application of a statute of limitations after the statute. So there was an initial statute that was in place when the act of sexual assault occurred. Before that statute expired, there was an amendment to that statute, which expanded the statute of limitations. And the criminal defendant in Russo was prosecuted under that amended provision. And what the court said was, well, he doesn't have a vested right. That's at issue here. It's okay for us to retroactively apply this amended statute. They implied in what is clearly dicta, they say had the statute of limitations, which it didn't happen, which is why this is dicta, had the statute of limitations completely expired, as to Mr. Russo, then perhaps he would have had a vested right. But riddled throughout that opinion are concepts of criminal law that, again, don't apply here. The court was concerned with things like ex post facto laws and how you can't change criminal liability after the fact, after liability has been extinguished. But they said it is fully permissible to use this amended statute to prosecute Mr. Russo. But interestingly, and this brings me back to one of the discussions that was happening earlier in this courtroom today in the provider case that was being argued by Mr. Gonzato and Mr. Gross. And we were talking about, well, you know, to what extent do we consider the intent of the legislature and the purpose of the legislation that's at issue? And in Russo, after the court says, well, when we go through these factors, it's okay to apply this statute retroactively, they say, by the way, let's look at what the aim of the legislature was here. And they say what the legislature did here was amended a statute of limitations relative to sexual assault. Because our legislature has this overarching policy objective of helping victims of sexual assault, decreasing instances of sexual assault, and our retroactive application of this statute today will only serve to further that purpose of the legislature. So the fact that Russo has ended up popping up inadvertently or tangentially in this case, I think is interesting because I think it does give this court a roadmap. It shows that neither the Diocese of Lansing, the Archdiocese of Baltimore, even though they're no longer a portion of this case right now due to the bankruptcy stay, nor Father Lobert, none of them have a vested right that is the type of right that this court is typically concerned about in his retroactivity cases.
We don't have any language here in the statute that would make it explicitly or retroactive, do we?
I wouldn't say it's explicitly retroactive, Your Honor.
If we look at subsection 3, it has that kind of language where the legislature clearly wanted the statute to apply to assaults that occurred before the effective date of the statute. Why would they not have used that language in the provision at issue in this case if they also wanted it to apply? Well, it's very strange that they would do it and be specific about it in the very same statute in one place but not another.
So, Your Honor, I don't think it is strange, respectfully. The reason why I think that happened, so first of all, a general point that I don't think anyone's going to disagree with me on, the retroactive application doesn't have to come from explicit language. Our case law says it can be explicit or implicit language. It just needs to be clearly stated. And I know this has been a big focus of yours, Justice Viviano, in your recent concurring opinions or dissenting opinions in this area of law. I know you're very focused on the statutory language. Section 3 does contain more specific language, but I would say that Section 3's specificity of language isn't to make it more clear that that is the section to be retroactively applied as opposed to the rest of the statute. It's because that statute was trying to collect the actual victims of Larry Nassar. The sides here all agree that that was what was premising the push behind this statute at first. And so, out of concern that we need to make sure all of those individuals who were assaulted by him are captured, they specified the dates that Larry Nassar was actually working with those victims. They described Larry Nassar's characteristics in terms of he's a licensed physician. So they did things to make sure that they brought in that whole class of people. But subsection 1, Your Honor, which doesn't include that language, admittedly, it uses other language, like when it says notwithstanding section 5805 or 5851, where it says at any time. That's language that generally implies that the legislature wants this to be a broad grant, a broad remedy given to people.
Didn't they consider some retroactivity language in this section as well, or am
I don't think that's properly before this court, Your Honor, frankly.
Well, let's answer the question first. Was it considered or not? Then we'll go to the second question of whether we should.
There were
think about
drafts
that.
of the bill that included retroactivity language, and the final draft of the bill that was passed did
All right,
not
now tell
include
me
that.
why you don't think we should consider that.
So defendant support for the idea, first of all, you know, again, citing to your own language, you've said over and over that the second that we start to delve outside the language of the statute, that's when mischief happens. I believe that's the phrase that you like to use. But defendant, when they cite to the type of legislative history that they use here, they acknowledge this court doesn't like to use legislative history, and then they say, but look at in re certified question, this is a 2003 opinion from this court, and it's footnote 5, it was a Justice Markman opinion. And in that case, Justice Markman talks about the different kinds of legislative history, and he says, as we said in a case called Miles ex rel Camphorbeek, so this is a 1923 opinion of this case, prior versions of a statute can be relevant. Well, when you go to Miles ex rel Camphorbeek, they weren't talking about drafts of the statute that were never codified. What they do in that opinion, and what this court will see, they walk through, a statute was passed in 1910, and here's what it said. Then it was amended, and a new version was passed in 1912. Then here's the one in 1917.
Hewing closer to the statutory history.
Yeah,
You're working too hard. I'm
well,
on this point.
sorry, Your Honor.
Let me ask you, because we're going to run out of time here, and I hate to switch gears back to where we started. I don't like going out of order, but back on the accrual point,
Yes.
I'm struggling with your argument that the discovery provision in 6851B is an accrual provision. This chapter 20 or 58, limitation of actions, has a lot of accrual provisions, and we know that because they use the word accrual quite regularly. So why would we think the legislature would amend one of those provisions without even using the word accrual?
So typically, Your Honor, accrual is addressed at 5827, and it says that if it's not in 5827, then it's governed by one of the subsequent
Specific
8 or
ones.
9 sections,
That
right?
follow, so that's the general one that seems to be applicable here, right? Unless we follow your argument on
Right.
5851B.
Right. And so, yeah, so the general rule is that accrual is addressed by 5827, and they certainly didn't amend 5827 to take sexual assault cases out of them.
And instead, just to flow it through, they put this 5851A and B after 5851, which is not an accrual section at all, right? I got my whole act here. Disabilities of infancy or insanity, attacking successes, disabilities prohibited, so on and so forth, the year of grace, and then we flow into this, so, you know.
Right. So primarily, Your Honor, I think my accrual argument, a lot of it comes from looking at the Trent to-do case and looking at the way that this case has talked about the intersection between accrual and discovery. And what Trent to-do did that I really like for purposes of today, it talks about the importance of honoring what the legislature says when it refers to accrual and it refers to discovery rules. And so here, even though they didn't do it very artfully by amending 5827, which hopefully...
You have 30 seconds left. so-
Thank you, Your Honor. While they didn't do it very artfully, Your Honor, I do think that was their intent here based on the language of that case law as it fits in with the rest of our case law regarding accrual and discovery. One quick point I want to say, and I know I'm running out of time, When we look at this court's recent decisions regarding retroactivity, a lot of the cases where we say we don't want to apply it retroactively, they involve statutory rights and contract rights that just aren't at issue in this case. That was the case in the Frank W. Lynch case where there were pre-existing contracts, in the LaFontaine case, and in the Indari case. And so we don't have the same sort of rights at issue here that has typically given this court pause.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. Tom Maher for the Diocese of Lansing. May it please the Court. This is a statutory interpretation case. It involves hard facts when you're looking at the sexual abuse of minors. But no matter how hard the facts are, the rules are still the same. The legislature balances the policies, the legislature draws lines, and the legislature enacts law. And then it falls to this court ultimately to interpret the law and to apply the law, knowing that the court's job is to apply the legislative intent. And my position is that a good analysis and the proper analysis of Section 5851B is that the legislature intended that subsection 1 would apply in favor only of minors who were victimized after the statute took effect. Subsection 3 could apply to other minors victimized before the statute took effect, only within the very narrow prescriptions of subsection 3. The interpretation I'm proposing, I think, is faithful to the legislative language. Note that if that is the plaintiff's interpretation is correct, I'm going to show you subsection 3 is completely unnecessary. Our interpretation gives meaning to all words. Our interpretation gives meaning to the legislative history, which I believe is extremely clear in this case. Our interpretation gives meaning to your precedents for many years, including Buell in 2021, including Andari last July. And our interpretation leaves it to the legislature to decide on this very difficult issue, do they want to change the law, and do they want to make it clear, if that is their intent, that a statute of limitations like this should apply retroactively. I think a very good starting point is the one that you made, Justice Clement, when you asked the question of, is there any limitations? You were asking that in the context of, is there any time limitation? Does it go back 40 years, 70 years, what have you? And counsel accurately said, no, there is no time limitation. But there's also no limitation on to whom it applies. Subsection 1 applies to all wrongdoers. There is no limitation. It applies to all wrongdoers going back as many years as you care to take it back. Subsection 3 is different, and we're going to get to the question of why would we even have subsection 3 if subsection 1 applies the way plaintiff is requesting to all wrongdoers, no matter when the abuse occurred? Why are we even worried about pulling in all of the Nassar victims? They've already been pulled in. They are victims who were abused. They are those wrongdoers. When it happened doesn't matter by plaintiff's analysis. Why are they concerned about pulling in all these Nassar victims when they're already covered by subsection 1? And I think that is the very important point that I see nothing in plaintiff's brief. I see nothing in plaintiff's reply brief. I see nothing in the amicus brief for the Association of Justice. I heard nothing. How can you reconcile the fact that subsection 1 is all-inclusive and argue that it applies for all time?
Couldn't there have been, or at least the possibility, or actually, victims of Larry Nassar that were over the age of 28 and 3 years had passed since the discovery? So they wouldn't have fallen in under A or B.
Right. The youngest known victim of Larry Nassar was 7 years old. This is laid out in the brief of the amicus supporting our cause. That statute is crafted so carefully that that youngest victim of Larry Nassar would not have been 28. They would have been 27. It certainly speaks to the notion that what people were trying to do was to make sure that Nassar could be sued. That's understandable. But I guess the question ought to be this. When you are looking that hard at the legislative process and you're drafting subsection 3 of this statute that you need a flow chart to work through, and that is the only provision that has retrospective language, and then you say nothing about subsection 1, I think it's very striking that when, as this court has said for many, many years, when the legislature wants to make its intention known, it knows how to do that. When the legislature wants a statute to apply retroactively, it knows how to do it, and we could go through dozens of acts where the legislature says this act is to have retroactive effect, and they did not do that here. What they said instead is that as to this group in subsection 1, we will allow these individuals to whom this act benefits, starting from January 12, 2018 forward. If you have been victimized, your statute of limitations will be until age 28, or it will be within the discovery period. But if you were victimized before this date, the only retrospective language goes to the Nassar victims. And I believe that I have to hear an explanation for why subsection 3 even exists if subsection 1 is as all-inclusive as plaintiff is arguing. I think I'll jump, because of the questions that were being asked, to the notion of vested rights. Plaintiffs rely on a Court of Appeals case called Best Menaja, I'm not sure how to pronounce it, and it was just quoted to you. That's a 1991 case. Russo was decided in 1992. It's a criminal case. There are points of distinction. But Russo relied on in re Straits Estates, a probate law case. In re Straits Estate from this court says very specifically that a statute of limitations that has already passed, has already expired, creates a vested right. And that's what Russo cites in support of its conclusion that a statute of limitation that has already expired creates a vested right. So to the extent that there's an emphasis in this court or through plaintiff's argument that there needs to be a vested right, our law is in re Straits Estate. Our law is People v. Russo, both cases from this court. Our law are the two Court of Appeals decisions, Gorte and Davis, both of them after Russo. And as I say, their case precedes Russo. The conclusion should be that once the statute of limitations has expired, the defendant has a vested right that cannot be impaired except for in extraordinary circumstances. And I don't think I need to go through all of the language from all of the cases talking about how clear and unequivocal the intent must be. And when counsel talks about it need not be that clear, it could be implicit, not really. If you look at your Ramey case, that court said, if it's going to be implied, we need to see specific language, we need to see unequivocal information, removing all doubt that we could imply retroactive application. And I think, Justice Welch, when you asked about, well, if it's already expired, doesn't that affect whether they can, that really is the point. Before 5851B, the statutes were very clear. Accrual statutes are different than limitations period. And that's why we have accrual statutes that say, one after the other, accrual of claim, contract, accrual of claim, property, accrual of claim. The legislature is making extremely clear when all those causes of action accrued. This claim, and we should keep it in mind, the only claim alleged is negligence. And a negligence claim accrued at the time of the wrong. The issue is, can they take this 2018 statute and use a discovery rule that applies to people victimized after that date in order to revive a cause of action that's already expired. The other points I would make, given that the court asked us to argue the LaFontaine factors and whether they would allow for retrospective application or retroactive application, going through all four of them, I'm not concerned about if they're factors or principles or what have you. The first factor seeks specific language that provides for retroactive application, and of course there is none. The second factor asks whether this could be tied to antecedent events, and we all agree that factor does not apply here. The third factor says that the court has a general disdain for any retroactive application that would impair vested rights, which is exactly what would happen here, and these are vested rights. And the fourth one is related to the third, to the extent that the amendment would change only a remedial or a procedural feature of a law, then maybe that could be applied retroactively. That does not apply here because we have a vested right. And that's the exact approach that Andari took. I think that if you're going to apply the rules of interpretation that control so many of your cases, you're going to look at the language of the statute. If the language is ambiguous, legislative history, absolutely this court looks at legislative history. An in-re certified question shows you very clearly that when we are looking in particular at the enactment history, the different versions of the statute that went before the House and the Senate and that were rejected, of course you consider that, especially on this issue. We laid it out in our brief.
I haven't reread that footnote that Brother Counsel raised, but is that what was cited in that case, or was it previously enacted legislation? Not the drafts that went through. Those two things are very different.
I'm sorry, Your Honor, I missed the first part of the question.
I said, I haven't looked at that footnote again since Brother Counsel raised it, but there's a huge difference between bills that are going through, proposals that are being put up and shot down by either the House or the Senate, and actual legislation that is enacted 1 year, modified, amended the next year, a new act, so on and so forth, where you could have changes in the same sections that can tell you something about what the legislative intent is. It's different when you're talking about
I do understand your question now, thank you. This is what the court said in in-re certified question. By comparing alternative legislative drafts, a court may be able to discern the intended meaning for the language actually entered. So again, by comparing alternative legislative drafts, a court may be able to discern the intended meaning for the language actually entered. I think that when members of the House stand on the floor and then members of the Senate do the same, and they say to everyone within their House or their Senate that we think it is wrong that you would apply retroactive provisions to only the Nassar victims and not in favor of everyone else, and because of that, I will not vote for the act. And I've given you only 4 examples laid out specifically. When they say that and they're voted down, I think it's absolutely appropriate to see that and say, what did the legislature mean when they adopted this? And what these senators and representatives said on the floor, these were not general soft comments. These were very aggressive comments of opposition to the statute as it currently is written. Tough issue. If they wanted it to be retroactive across the board, they certainly fought over it. Your Honors, do you have any other questions?
I don't see any. Thank you.
Thank you.
Thank you both. The case will be submitted. We'll recess or adjourned until tomorrow morning at 9:30.